Bruce Rivers, he's the criminal lawyer.
But who is he?
Bruce Rivers, he's the criminal lawyer.
And who is he?
Bruce Rivers, he's the criminal lawyer.
And what he do?
And it's gonna react to all the self-snitching.
Hi, this is Bruce Rivers. Welcome to another episode of Criminal Lawyer Reacts. I'm Bruce Rivers, board-certified criminal defense lawyer. And today I am talking about Tory Lanez. Tory Lanez is a rapper, and he was charged in L.A. with shooting Megan Thee Stallion. Apparently they were at a party, and they were in a car, and he says, "Dance, bitch," and shoots at her feet, and the gun goes off. Now, that is, what you call a very reckless use of a firearm. I don't know if it happened or not. I know they did do DNA, and I don't know if his DNA is on the gun or not. I know there's a mixture of DNA. But here's what happened. He recently got taken into court for violating conditions of release. Basically, there was a protective order that prevented him from either contacting directly or indirectly Megan Thee Stallion, and some of his tweets were, or not tweets, or Instagram, however his social media posts were directed at her, it seems like. So the prosecutor, now let's just take a step back and talk about conditions of release. So when you get charged with a crime, the court can impose conditions, on you while the case is pending. For example, in a domestic case, you might have a condition of your release that you cannot go to your home, you can't have contact with your wife or your girlfriend or whoever the protected person is. And so if you violate that condition, they issue a warrant. And when they issue a warrant, they take you into custody. And then you have to have a bail hearing or some kind of hearing after that. So the court can impose any kind of conditions on your release. And in this case, they said the court said you violated your conditions of release. We're going to do something different now. And so he had initially had $250,000 bond. So he posted that bond, obviously, and it was out until his case happened. And so when they bring him in, he was arrested last week. And when he got arrested, the district attorney had asked for $5 million bail, to revoke his bail completely. And the judge did not go with that. He went with the argument of the defense, and the defense asked him, I don't know what they actually asked for, but he wound up just adding another $100,000 to the bail, which, 10%, you put $10 more $1,000 into the kitty for the bail bondsman, and you're out in short order. So they had a preliminary hearing, and a preliminary hearing, not every jurisdiction has them, but what a preliminary hearing is, it's a hearing to determine whether there's probable cause to get to the jury, basically. Is there enough to bind this case over to a jury? And in this case, the judge said that there's enough evidence here to go to a jury. And so during that hearing, they talked, the prosecutor brought out the fact that he said, "Dance, bitch," and then the gun goes off. And then his defense attorney says, "But no one heard 'dance, bitch' except for Megan," correct? And the officer says, "Yes, that's right." So, I don't know how this is going to shake out. There's a trial date set in September. But let's kind of look at the facts of a case like this. So this is an aggravated assault. It's a felony because it's with a firearm, and you have an injured party. So Megan's feet were bleeding at the time that this happened, and but he denies that he shot anybody, and Megan's the only one that hears the term "dance, bitch." Now, if there's no DNA on the gun, does that mean that they can't convict him? No, not necessarily, because they don't. It's very often that they don't find DNA on a particular firearm, and I believe if his DNA is on it, there might be a mixture, so that it might be inconclusive. It all depends upon what the DNA profile shows. If his DNA is on the gun, what that means is at some point he touched the gun. So if you have Megan saying, "I saw him point the gun at me and shoot," that's direct evidence, and that's powerful stuff. Her injuries to her feet, one could argue that she wouldn't have gotten them any other way, other than and when the cops originally stopped the vehicle, and she was afraid she was going to get in trouble, and she was crying and she was bleeding, and I mean, so you take all those circumstances into account, and and there's no plea deal that's been offered. So, when there's no plea deal, you go to trial. That's what you do. So, but this is a good example of what not to do, and of how not to use a firearm. Very reckless. I mean, when you go to the club, leave your gun at home. Because even if you have a permit to carry, most permit to carries are invalidated with the use of alcohol. So they usually have a little disclaimer on the permit on your card that says it invalidates it if you are drunk or if you use any alcohol. My advice to everybody is live to fight another day, and do not take your gun to town. So when you have a case like this that's not, it's being denied, some of the things that you need to look at, like, for example, let's see, the victim identified in court was Megan P. Described the injuries as the bleeding profusely, and she fell to the ground and crawled to a nearby driveway, according to the detective. That's what they said in the preliminary hearing. She said that the female friend of hers who had been in the vehicle ran up afterwards along with Lanez, and that he emphatically apologized for what he did. So that's what you call consciousness of guilt. I'm really, really sorry. I'm really, really sorry. And then he denies it later. Well, you apologized. That's an issue. So that trial's coming up in September. And so we'll follow that. I like to follow all these bigger cases because it's just interesting to the fans. And if you guys have any other ideas, don't hesitate to put in the comments. We read the comments, all the comments. And some are more appreciated than others, but all are overwhelmingly positive. And that's what we're trying to do here, is present a positive message, inform, entertain. And there you go. So don't take your guns to town. That's my advice to you guys. And we'll see you next time here on Criminal Lawyer Reacts. Make sure you follow us on Instagram, follow us on Twitter, spread the word. And we got Patreon out there to help some folks who can't afford bail. So let's get those numbers up there, and we'll do some good work. So we'll see you next time here on Criminal Lawyer Reacts. Now, when Cortland arrived, Melly was already there at the house. Is that reasonable doubt?
Bruce Rivers, he's the criminal lawyer. Who is he? Bruce Rivers, he's the criminal lawyer. And who is he? Bruce Rivers, he's the criminal lawyer. And what he do? And he's gonna react to all the self-snitching.
This is Bruce Rivers, Criminal Lawyer Reacts. I am a board-certified criminal defense lawyer, and we are going back-to-back coverage of the Melly trial. Today is his best friend testifies to defend him. Well, and I haven't seen this, so we'll see what it is. But I'm coming to you with my Pearl Handle pistol cufflinks with our content genius behind the camera and behind all the ideas in this channel, Michael Rivers. But before we get to that, we're brought to you by eSign.com. eSign.com, a very effective way to remotely do business. So, for example, if you have a power of attorney or a bill of sale, like my grandma just bought a motorcycle, and I don't know how she bought a motorcycle, especially since I have a power of attorney, but she called the dealership and they just e-signed a document over to her. She's super savvy with the computer. And they download the app, you get 3 free signatures a month, and away you go. It's a very easy and quick way to remotely do business. So, eSign.com. If it's not eSign, no one signs. Let's just get right into this because, I don't know. This is almost in the form of character evidence. I don't know what the heck he's going to say. I don't know what he could possibly say, but it doesn't seem like they are really calling that many witnesses.
Who was the last person to get out of the red Mitsubishi to go inside the house?
Trayvon, he was in the car still asleep.
He was in the car asleep when you got to his house?
Yeah.
Did you see where Melly went?
To his room.
And where was his bedroom?
When you first walked in the house.
So this is a witness, aside from being the friends told him, he sees them right after the homicide. So, pretty kind of important.
House.
2.
Where did you go Where did Dontavius Withers go? Where-
Compound question.
I'll bring it up.
Thank you.
Do you know where
Compound question. You can't ask a question that's got two answers. So, where did you go after you put on the hat and you went to the store? And, you know, when you have a bunch of different things in the question, you can't ask it that way.
Dontavius Withers went?
To his room upstairs.
Do you know where Trevon Glass went?
To the room upstairs.
Do you know where Jacoby Mills went?
He slept on me.
So the three of you, the four of you went upstairs,
Yeah.
correct? And this young man went into his bedroom.
Objection leading.
Yes.
Rephrase.
Where did this young man go? So she just objected, objection leading. She probably could have let it go. But and leading questions are, you know, isn't it true that he went upstairs, as opposed to where did he go? So the witness has got to come up with the answer as opposed to yes or no.
How many people went upstairs to go to sleep?
30.
And you?
Yeah.
That would be,
Me, Jacoby, Melly. Well, no. Melly was downstairs in his room. Me, Jacoby, Fetty, and Tay. So 4 of us.
okay. And Melly went to his bedroom?
Yes.
Did there come a time in the early morning hours that you were woken up and heard some distressing news?
Now this is critical because this is right during the time in question. And the jury on this one is probably on the edge of their seat.
Yes.
What did you hear?
That second Julie was shot.
When you heard that, did you see Melly in the house?
Yes.
Did you see Melly how he was dressed in the house?
Yes.
What was he wearing?
Shorts and a t-shirt, I think.
Okay. Upon hearing that Sack and Juvie, and I really should use the correct names, Anthony Williams and Christopher Thomas, were shot. What did you guys do?
We were already dressed and stuff, so we just left with Fredo's house.
Was anybody upset or crying?
Yeah, we all were crying.
I think a good question. Where was Melly before this? And how did Melly even know about this?
Man crying?
Yes.
Are you sure of that?
Positive.
Your Honor. Preston Laser.
And where'd you go?
Fredo's house.
That would be Fredo Bang.
Yeah.
Do you know Fredo Bang's real name?
No.
Frederick Gibbons, by any chance?
Yeah, I think I've seen it.
Did there come a time after you got to the house of Fredo Bang that Cortland Henry showed up?
Yes.
Did Cortland Henry tell you all what happened?
Yeah, he said it was a drive-by.
All right. Did Cortland Henry tell you what happened? Now, you remember that the state's already played his statement. So if he comes in and says it's a drive-by, not Mr. Davis, but Mr. Henry, and he says, well, he told us it was a drive-by, is it hearsay? Hearsay is a statement other than the declarant offered for the truth of the matter asserted. That's what hearsay, and hearsay is inadmissible unless there's a certain exception. One could argue that they're not offering it for its truth.
When Cortland Henry arrived at Fredo Bang's house, was Melly there?
Yes.
Now, when Cortland arrived, Melly was already there at the house. Is that reasonable doubt?
Did you eventually leave that house?
Yes.
Approximately what time did you leave that house?
I really don't remember.
Where'd you go?
Back to Jamel's house.
Who went with you?
Me, Trayvon, Jacoby, and Fetty.
By the way, when you first learned that Anthony Williams and Christopher Thomas were shot at the house with Melly, did anyone get on the phone?
Yeah.
Did anyone have any problem locating their phone?
Yes.
Who was that?
Jamel.
Oh, now he can't find his phone. Somebody else texted, I did that. Curiouser and curiouser.
When I backed up for a minute, you were telling the jury that you went back to Melly's house.
Mm-hmm.
You got to answer yes or no.
Yes.
She can't shake down, shaking your head. How'd you get in?
The door is unlocked.
Oh, now its door's unlocked to Melly's house. So, having trouble finding his phone. He's not with Bortland Henry, and his door's unlocked.
Were you aware whether or not Melly had a contractual agreement to do a video shoot that day?
Yeah, it was something like that. I know he probably would have lost a lot of money if he didn't go to the music video. He was upset.
Was Melly crying at Frito Bank's house?
Yes.
Were you crying?
Yes.
Because you all grew up together.
Mm-hmm. Yes. Yeah.
Did you, in fact, tell this what happened on October 25th and 26th to this particular prosecutor?
Yes.
Meaning, I told him all this, but they didn't call me as a witness. What are they hiding?
Were any of us, any of the lawyers present?
Objection, relevance.
Sustained. When you try a lot of cases, you can kind of see how things are going to go.
Did you tell the prosecutor when you spoke to the prosecutor? Were you under oath,
Yes.
sworn to tell the truth?
Yes.
Are you 100% sure?
Objection, asked and answered.
I'm gonna-
She's got to let him get the fucking question out.
that Melly got into the red Mitsubishi to go home?
Yes.
Are you 100% sure that this young man learned of the shooting of his friends at the exact same time you learned of it?
Yes.
That's an alibi witness. So he just asked him two questions that, if believed, could exonerate him. So that's one of the reasons why I think they're not putting on a big dog and pony show.
And that was at the house.
Yes.
Are you 100% sure that when people were getting on the phone, that this young man was looking for his phone to call people?
Yes.
Nothing further, Your Honor. Let's sum up Mr. Davis's testimony. I mean, he testified about a lot of stuff, right? Just how he knew everybody and he's their friend. He testified about three key factors. One, that Melly got into the red car, not the other one. That Melly was home when he found out about the death of his two buddies. And the third thing is that he was looking for his phone. His phone wasn't anywhere near him. My gosh. So, That will all be tied into the closing arguments that they'll probably do tomorrow or the next day. So, if the jury believes Davis, he could be acquitted. But for them to believe Davis, you would have to disregard all of the other evidence. Or would you? Tell us what you think in the comments. I'm Bruce Rivers, board-certified criminal defense lawyer with our content genius, Michael Rivers. Make sure you subscribe, follow us on Instagram, follow us on Twitter, sign up for Patreon, and we'll see you next time here on Criminal Lawyer Reacts.
Bruce Rivers just broke down your case. He know all the charges that you about to face. You ain't coming home till 2058. That self-snitching gon' get you put away. Bruce Rivers just broke down your case. He know all the charges that you about to face. You ain't coming home till 2058. That self-snitching gon' get you put away. 23-hour lockdown, please is at my god.
Hey, Steve.
I ain't doing I got gun right there. I'm not doing that.
Oh, yeah.
Oh, yeah! What the f***? I mean, honestly, it's so demeaning. So absolutely demeaning. I cannot stand it when they get so worked up. This fucking cop, did you see the disdain she had for him? You know, you don't have to be disrespectful if you're a cop. I get that you have to use a certain amount of force. Your voice has to have a certain amount of authority.
Bruce Rivers, he's the criminal lawyer. Bruce Rivers, he's the criminal lawyer. Bruce Rivers, he's the criminal lawyer. And what he do? And it's gonna react to all the self-snitching.
Hi, this is Bruce Rivers. Welcome to another fun-filled episode of Criminal Lawyer Reacts. I'm Bruce Rivers, your very own board-certified criminal defense lawyer, which means I actually go to court and I try cases. I try cases like, any one of our episodes, I probably tried a case just like that. I've been practicing for over 25 years, and our content genius is just behind the camera and behind every idea, and he's just an amazing dude, Michael Rivers. So today we're reacting to an arrest of a dude who got tased by an Alabama officer. You know, whether you're a CEO or you are a cop on the street, we all have power, right? We all have a certain amount of power, and I hate it when anybody abuses their power. But before we get to this episode, let's talk about who this is sponsored by. This is sponsored by eSign.com. eSign.com is a very effective way to remotely do business. Let's say you're an Alabama cop who just got put on leave and you're sitting in your basement because you just got put on leave for misconduct. Well, you need to get a hold of your union rep and maybe sign a new retainer agreement because you need a lawyer. Well, guess what's going to happen? That lawyer is going to email you a retainer agreement because they've downloaded the app. You get 3 to 5 signatures a month for free. After that, you sign the document remotely and you're good to go. I use it all the time, and it's good for just about anything. eSign.com, a very effective way to remotely do business. Because if it's not eSign, no one signs. Okay, let's get into this. This is just, I have seen this one. We're in Alabama, first of all. We don't exactly know why he was stopped. But he was stopped, and then I think they find a gun later and all this other stuff. But this woman's not assaulted. She may have encountered some resistance. But watch what happens, and this is after he's in handcuffs. And I have to kind of warn you, this is graphic.
Right there on the front of the car.
Now, I don't have the footage beforehand to find out why she's so pissed off. But at this point, he's in handcuffs, and he's complying with all of her demands.
Hey, Steve.
I ain't doing I got gun right there. I'm not doing that.
Oh, yeah.
I'm saying what you saying. Oh, yeah, for. I'm not. Oh, my God.
He's laying down. He's defenseless, and she tases the shit out of him. This is not okay. This is called excessive use of force. This is protected by 42 U.S.C. 1983, denying of his civil rights. Now listen. Now watch this.
Okay, down.
She shut the fuck up. You know, cops that are abusive like this have a low IQ, and they do shit like this because they don't have any other way to solve a goddamn problem.
Oh my God.
You want it again?
No, man.
Shut the You was big and bad. Shut your
Okay. So she's got him, in a very submissive position. He's crying. He wasn't resisting her at the time at all. But this begs the question, why did she go ham on him? And why did she do this? Shut the fuck up. I can't really make out exactly what she is saying.
You want it again?
You want it again? You want it again? You're being big bad, whatever the fuck she says. You don't have to be disrespectful if you're a cop. I get that you have to use a certain amount of force. Your voice has to have a certain amount of authority. But you don't have to be disrespectful. You don't have to say shut the fuck up. You don't have to call them names. All I can say is that this is what it is. So now let's kind of find out what he was charged with and, what happened next.
They held a protest Monday night in response to the viral video showing a police officer using a stun gun on a handcuffed man. We want to warn you, you might find this video disturbing. After an
I'm not going to discount the fact that he is probably twice her size. She's a female. He's a big guy. And so he can overpower her probably pretty easy. But he is in handcuffs. And he was complying at the time that he was tased.
Exchange of words, the police officer pulls the trigger on the stun gun and then asked,
You want it again? No, man. Shut the f up. You was big and bad.
She could then be heard calling him an explicit name.
She tased him in the back, and she was holding it. She was just holding it there until he started crying.
Jalexis Rice, girlfriend of Micaiah Washington, says this all started when her boyfriend and two others were changing a tire of the car they were driving. She says that's when the officer in the video pulled up, eventually putting her boyfriend in handcuffs and tasing him.
So, all right, so you've got a situation where you're on the side of the road and you're changing a tire. Happens to a lot of people, right? That is not a crime. You're in distress. So they can do a well check on you. I mean, so there's no issue with the officer doing a well check. But when you go beyond that, now she probably asked him for his ID, saw that he had a record, and now I want to search your car. That's how these things kind of get out of control. So if you have a felony on your record and you have a gun in the car, guess what's going to happen? And you get pulled over. They're going to search your car. They're going to find that gun. And then you're going to get a 5-year mandatory minimum because you're in dumb shit for having a gun and being a felon. But doesn't mean, no matter what his situation is with the firearm that they found later, it doesn't mean that he should be subject to this kind of treatment. We have a new sponsor, Step 1, high performance underwear. With this viscose fabric derived from organic bamboo, you're cool, calm, and collected. I wear them all the time. They've got these panels. They got the panels so you don't chafe. They got the material so you don't sweat. And they're comfy. I wore them for 8,500 miles on my motorcycle trip. If you put in the code Bruce Rivers as you go to checkout, when you get like 6 to 12 pair, get at least that, you'll get 25% off. Christmas is around the corner. You get these for your guy. He is going to love you. He probably already does, but he's going to love you more. Get Step 1. Step 1, get some.
I couldn't do nothing but cry. I couldn't do nothing but cry.
Following his arrest, Washington was booked into the Pickens County Jail on several charges. He has a bond of $500,000. In a statement, Reform's police chief and mayor said they're aware of the video and the police officer has been placed on administrative leave. However, people attending Monday's rally say they want more done.
She needs to be fired, and I feel like she can leave and go somewhere else and do it if they don't hold her accountable for nothing. You're a police. You're here to protect and serve us. How do we supposed to trust you and this how you treat us?
It hurt my feelings for real.
There's absolutely no reason for him to be tased while he's on the hood of the car. I know some people will kind of give some fanciful, reason, but no.
In the statement from the mayor and police chief, they said in part, the department is in the process of turning over all materials related to this arrest to the Alabama State Bureau of Investigation and has requested a thorough investigation into the circumstances surrounding the arrest.
Now, we don't see what happened before he was put in cuffs. But it doesn't justify what she did. And let's just kind of look at his charges here. So we've got obstructing governmental operations, whatever that means, resisting arrest, which he probably might have done, early on, because he didn't want her to find the gun. Marijuana possession, who cares? Ex-felon in possession of a firearm that they probably found in the car, and drug trafficking. And that just, all drug trafficking is having some dope in the car as you're driving, transporting marijuana or transporting whatever. And his bail's $500,000. Welcome to fucking Alabama. I mean, why would his bail be so fucking high? Unless he's got a lot of non-appearances. So there's a lot of unanswered questions here. But my guess, and I can kind of forecast these things, right? I can tell you that he probably has a lengthy record, I'm guessing. He's got at least one felony. He probably has some failed appearances. And that's probably why his bail is so high. Otherwise, unless, for felon in possession in Alabama, that $500,000 is a normal bail, which I can't imagine it would be, but it very might be. And it's tough to watch. Isn't that tough to watch? Somebody crying on the hood of a car. But a lot of this could be taken care of just by a little bit of pre-planning. Don't have that gun in the car. Don't have that dope on you. Make some better plans. But this fucking cop, did you see the disdain she had for him? This little broad she's talking through her fucking teeth. I mean, look at him. This is just a still. I mean, he is in agony, and granted, she's little. There's no question about that. But the disdain she has from him. Let's just watch that again real quick.
Stand up. Right there on the front of the car. Stay straight.
I ain't doing I got gun right there. I'm not doing that.
Oh, yeah.
Oh, yeah. Oh, yeah. I got you now, boy. What the fuck? I mean, honestly, it's so demeaning. So absolutely demeaning. I cannot stand it when they get so worked up. And these people, these cops, not all of them, there's a lot of good cops out there. But, to your education, if that, a lot of times you can just take the skills course, which is however long. You don't need a college degree to be a cop, and they handle really complex problems in delicate situations. They need more training. They don't need to be king shit whatever, and her talking to him the way she does and the amount of disdain she has. She's talking through her teeth.
I'm saying what you saying. Oh yeah, I'm not. Oh my God. Okay. Down.
Shut the fuck up.
My fault. Oh my God.
First of all, she should have a backup on this. She should have had him stay in his car or do whatever or lay on the ground until she got back up because she's so little. Anyway, there's a whole host of police procedures that she violated by doing what she did. Anyway, I just hate to see this. I hate to see anybody abused. Michael just asked me an interesting question. Do you think that the way he was treated by the officer will have an impact on what's going to happen in his criminal trial? It may or may not. When you have an officer do this, it really is a violation of your rights. But, I mean, does the officer have cause to inquire beyond the tire? Because if you file a motion to suppress the search of the vehicle, then the whole case goes away. The whole case goes away. And just so you know, you do not have the right in any jurisdiction to resist an unlawful arrest. I'll say that again. You do not have the right in any jurisdiction to resist an unlawful arrest. The remedy for an unlawful arrest is suppression of evidence, not your own resistance. Because if you resist, then you can get another charge, resisting an officer or obstruction of justice. My heart goes out to this guy because he's probably got a record. He's riding around dirty, for lack of a better word. And, I hate it when I see, in an innocent situation, people fuck up and, turn it into a much bigger situation, which is what happened here. So we'll see you next time here on Criminal Lawyer Reacts. I'm Bruce Rivers, your board-certified criminal defense lawyer with our content genius, Michael Rivers. Make sure you subscribe, follow us on Instagram, follow us on Twitter, sign up for Patreon, and we'll see you next time here on Criminal Lawyer Reacts.
Bruce Rivers just broke down your case. He know all the charges that you about to face. You ain't coming home till 2058. That self-snitching gon' get you put away. Bruce Rivers just broke down your case. He know all the charges that you about to face. You ain't coming home till 2058. That self-snitching gon' get you put away. 23-hour lockdown, please is at my God.
Bruce Rivers, he's the criminal lawyer. Bruce Rivers, he's the criminal lawyer. Bruce Rivers, he's the criminal lawyer. And what he do? And he's gonna react to all the self-snitching.
Hi, this is Bruce Rivers. Welcome to another episode of Criminal Lawyer Reacts, CLR. I am Bruce Rivers, board-certified criminal defense lawyer. Today's episode is brought to you by eforms.com, where you can get your lease agreement, you can get a power of attorney, just about anything you're looking for. You sign up now, you can get a 7-day free pass. Anyway, so today we're talking about Amber Heard's failed attempt at trying to get her lawsuit thrown out. A judge on Wednesday rejected an effort by the actress Amber Heard to set aside the $10 million judgment awarded in her favor. Now, she's also being sued, and she's not really being sued, but she is being sued by her insurance company. Now, her insurance company, we'll get into what the judge said in a second on that thing, but I think another interesting thing is that her own insurance company is filed what they call a DEC action. It's they are asking for declaratory judgment against Amber Heard. Why are they doing this? Well, they're saying that the acts that caused her judgment against her were intentional acts. And when you have coverage, like my auto coverage, if I deliberately run over my ex-wife's boyfriend because I fucking hate his guts, I wouldn't be covered because it's an intentional act. And so they're saying what Amber Heard did here was intentional. In other words, she's defaming Johnny Depp. She got sued for it. We're not going to cover you because it's an intentional act. So some policies, for the ultra wealthy do cover intentional acts, but she's not the ultra wealthy, and she is fucked when it comes to her insurance. And I'm pretty sure she's going to get fucked here by her insurance company. Anyway, so the judge on Wednesday issued an order throwing out her motion. Heard filed a motion seeking to have Johnny Depp's verdict set aside and to have a mistrial declared. And one of the things that she said was the mistaken identity of a juror. Well, they had all the information they needed. They could have brought it up during the trial. But the judge, she rejected all of Heard's claims and said that the juror issue specifically was irrelevant and that Heard can't show how she was prejudiced. So sometimes there can be a technical violation of the law, right? For example, prosecutors are not supposed to say in their closing argument, you need to send a message to the community, blah, blah, fucking blah. They can't do that. But guess what? You know what the Court of Appeals generally says? They committed misconduct, but it was harmless error. So in other words, they weren't prejudiced by it. And so that's what the judge is saying here. The juror was vetted, sat for the entire jury, deliberated, and reached a verdict. The only evidence before this court is that the juror and all the other jurors followed their oaths and the court's instructions and orders. The court is bound by the competent decision of the jury. That's what she said. I really like that judge because I watched a good chunk of this trial, and I thought she did a good job. So, among other things, Heard argued that the $10 million verdict was unsupported by the facts and seemed to demonstrate that the jurors failed to focus on the fallout from the 2018 op-ed piece as they were supposed to do. Instead, just looked broadly at the damage Depp's reputation suffered as a result of the alleged abuse. Heard's, one of the things in this fucking trial is they let in so much shit, which really just showed you what an absolute dysfunctional hellhole that whole relationship was. And it's just like, why would you want to spend one day in that? I wouldn't wish that on my worst enemy. Maybe my worst enemy I'd wish it on, but not, let's see. Elaine, you remember Elaine? She said the dueling verdicts are inconsistent and irreconcilable. Her lawyers, but they're not. They're not at all. And if you remember when I did a reaction to her filing this, I told you it wouldn't go anywhere. And guess what? It never went anywhere. They challenged the verdict on the basis that the 7 jurors who decided the case were never summoned for jury duty. According to the court papers, a 77-year-old county resident received a jury summons, but the man's son, who has the same name and lives at the same address, responded to the summons and served in his stead. Heard's lawyers argued that the Virginia law is strict about juror identities, and the case of mistaken identity is grounds for a mistrial. They presented no evidence that the 52-year-old son identified in the court papers only as juror number 15 purposely or insidiously sought to replace his father, but they argue that possibilities should not be discounted. So Elaine is also saying that the court can't assume that, as Mr. Depp's asked the court to, that juror number 15 was an innocent mistake. But here's the thing. In a sense, what difference does it make? If he's a qualified juror otherwise, and he's just not the person that was on that summons, what difference does it make? You had a chance to vet that juror. You had the chance to ask that juror any questions, and the juror fulfilled the oath as the judge said. So one of the things, if you're at all interested, the judge unsealed a bunch of the documents, like requests for independent medical exams of both parties, and then they open themselves up to public scrutiny when they file stuff in public court. So if you're interested in that kind of thing, you can go to the courthouse, you can go through their file and see stuff that you didn't see during the trial. I don't know why you would do that, because don't you just already feel kind of dirty watching that trial for as long as you did? So now that the judge has ruled that she doesn't get a new trial and that she's not tossing out the judgment, there the judgment sits. And sits and sits. And while it's sitting there at $10 million, that judgment accrues interest at whatever the statutory rate is. So she's got a choice. She can and really what she should do is just drop this fucking thing and try to make some accommodation to Johnny and say, look, let's just go our separate ways. And he probably would do it. But he may not, because she's dragged him through the fucking mud this far anyway. But she has a choice. She can put up a bond and file an appeal if that's what it requires, and which she probably can't afford the bond, or she can just try to dodge the judgment, because what'll happen is if she only gets so many days to appeal. Generally it's about 60 days to file your notice of appeal. And just because you file a notice of appeal doesn't necessarily mean that you have to follow through with it, but you can file your notice of appeal. But if they require a bond, you got to pay that bond. Otherwise, you can't proceed with your appeal. And what does that mean? That means you file a bond so that if you lose your appeal, the judgment's covered by a bond. But who's going to fucking cover that bond for her? Who would do that? Nobody. Nobody would. Because here's the other thing. When an insurance company certain insurance companies are the ones who put up the bonds, right? They're their surety. And so, for example, you put up a bail bond, you pay 10%, like on $100,000, you pay $10,000. And then you put collateral up to secure the other $90,000. So if you don't show up to court and the judge revokes your bond, you owe that other $90,000 or for the full $100,000, right? And so it's the same thing here. You lose that trial, that bond company has to pay the bond, and then they go after you So, and if you don't have the collateral, you don't have any money to satisfy that judgment, you're not gonna get anything. And here's the other thing. Guess what happened after this trial? You know, I still look back at the very first video that I did, where I said, why is he doing this? Blah 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 blah. I was so stupid, to be honest with you, because I was just looking at it from, you know, he talking about his drug use, and you know, I'm trying to be conservative about a public image, you know, but he does have kind of a recluse image anyway. That's kind of his charm. And but if you look at what has happened since, now I don't know if it's true or not, but rumor has it he has been offered $300 million to reignite the Pirates of the Caribbean series. I don't know if that's true or not, but if it's true, guess what? Mission fucking accomplished by Johnny Depp and his team. I mean, and they were such class. They were just class all the way. And that's the way you do it. You know, but it's really hard to represent somebody like Amber Heard, who just seemed like she was so full of shit at every turn. You know, and she had many opportunities to turn that around. And so, you know, I wish her the best. I mean, I wish everybody the best. But, you know, you keep stepping in dog shit, you're eventually going to start smelling like dog shit. So this is our reaction to the latest saga in the Amber Heard versus Johnny Depp. Let's, you know, maybe she just gives the $7 million back to him and call it a day. I bet he would do that. But then she's got nothing. She's Zippo. So this is Bruce Rivers, Criminal Lawyer Reacts. We'll see you next time. Make sure you like, follow, listen to this outro with Percy Mack. And follow JLap, follow Percy Mack. Find us everywhere you can on Patreon. And we'll see you next time here on Criminal Lawyer Reacts. I'm part of
Bruce Rivers just broke down your case. He know all the charges that you about to face. You ain't coming home till 2058. That self-snitching gon' get you put away. Bruce Rivers just broke down your case. He know all the charges that you about to face. You ain't coming home till 2058. That self-snitching gon' get you put away. 23-hour lockdown, please just my God.
Bruce Rivers, he's the criminal lawyer. Bruce Rivers, he's the criminal lawyer. Bruce Rivers, he's the criminal lawyer. And what he do? And it's gonna react to all the self-snitching.
Hi, this is Bruce Rivers, board-certified criminal defense lawyer. Welcome to another episode of Criminal Lawyer Reacts. Today we're going to talk about a few things in the news. We're going to talk about Glock 9. We're going to talk about Donald Trump. We're going to talk about Pooh Shiesty, Alan Weisselberg, and a couple other things. But to start off with, there has been a major indictment out in the East Coast, or West Coast, sorry. Glock 9 and Hot Boy are among two of the almost 3 dozen people that have been indicted in Orange County. The feds have gone after these guys for a number of things. There have been 30 shootings in the last several weeks, and the shootings have resulted in the death of one small child and a 14-year-old, among other people. Now, the feds have stepped in on something like this, and this is a very large racketeering. It's a RICO case. RICO was a statute created back in the 30s to combat organized crime. Now, what it basically does is it creates a series of crimes in the way people are acting together in concert. And so when you have all these different people, they call it the organization. It's a Corrupt Organizations Act. And basically, when people are acting in concert with each other and they form an organization whose primary purpose is criminal, whether it be drugs, murder, guns, whatever it happens to be, and in this case, it's all three. So we have a situation where Glock 9 has been taken into custody, and his bail is $750,000. I don't know if he can make that or not, but I'm surprised that he actually has any bail. But be that as it may, in Orange County, that's one of the counties where you have a very liberal bench out there. So it's not that hard to get released from federal custody as we saw with NBA YoungBoy when he got busted in L.A., he was released, but then the magistrate ruling was appealed by the government, and they kept him in custody. So one of the things that happens with these multi-defendant conspiracy cases is that the first in is the first out, basically, and they are snitch central. So what's going to happen is there are going to be all kinds of snitches in this case. Just watch. But whether Glock 9 gets out or whether Hot Boy gets out, you don't want to make any kind of assumptions if they get out that there must be snitching, because generally people who are bonding out aren't necessarily snitching. But it's a very complicated indictment, and when you have these kinds of indictments, the federal guidelines for these sentences just go through the roof. They can be anywhere from 188 to 235 months all the way up to life, depending upon what the situation is. And if any of these people have 2 or more violent crimes in their past, they could potentially be part of the Armed Career Criminal Act, which means that you can have much higher mandatory minimums that the judges don't have any authority to go beyond. So we're going to follow that Glock 9 and Hot Boy and find out where they go. And people wonder, why is this important? Well, it's important because this is on the street, and the feds are taking over some of these larger cases, especially where it seems like that the locals are kind of outmanned, outgunned. And that's why you have such a large indictment on something like this. Now let's talk about Pooh Shiesty, because that's exactly what happened in Pooh Shiesty's case. Pooh Shiesty just got recently indicted. He has a detention hearing tomorrow. So what happens is you get indicted by the feds, and his indictment relates right back to some of the same stuff that he was in court for just a few weeks ago. And one of the things that they said in Pooh Shiesty's case is that the social media posts that he put on, for example, there was a $100 bill that they were able to link up to the scene because there was a bag that fell out of the car after the shooting, and that bag contained $40,000 in cash, and one of those bills matched the serial number on social media, on Instagram. And then they also linked him up with his car as well. And those social media posts can really wind up haunting anybody who's trying to avoid detection. And so they have now filed federal charges on Pooh Shiesty. So he's now in federal custody. And so they have to bring him before a magistrate. We have the magistrate and then the district court judge. When they bring him to the magistrate will make a ruling as to whether or not he gets released. This is in Florida, so I don't think he's going to get released. I think he's going to be held without bond. That's my guess. I can't say that for certain, but that would be my guess. If he's allowed to post a bond, it would be significant for sure, because he was already out on bond when he got the new charge. So what'll happen is the magistrate makes a ruling. If either the government or the defendant don't like that ruling, they can appeal that ruling to the district court judge. Now, remember we saw that with NBA YoungBoy. They let him out in L.A., but the judge that was the district court judge in charge of it actually heard the appeal from the government and then reversed what the judge in L.A. said, or the magistrate in L.A. said, and they kept him in custody. That could happen here. But if the magistrate in Florida decides, Mr. Shiesty, we're going to release you on these conditions, the government could appeal that to the district court judge. Vice versa, if the judge says we're going to keep you in, the defense can appeal that. So that's a couple different cases with people that we've been following. And lastly, let's talk about a couple of major celebrities in the news. Right? So last week, the Trump Organization and CFO Alan Weisselberg were both indicted. Now, Weisselberg was indicted on a tax scheme going back 15 years, where he received a car, an apartment, tuition for his children or grandchildren, and a whole host of other fringe benefits that he never paid tax on. And then the organization actually got indicted as well. You saw that, I don't know if you saw the rally that Trump held in Sarasota recently, and he essentially admits that in the rally, to the facts that would support, the charge, basically, that, we didn't pay tax on any of that stuff.
And yet they go after good, hard-working people for not paying taxes on a company car or a company apartment. You used an apartment because you need an apartment, or education for your grandchildren. I don't even know. Do you have to? But does anybody know the answer to that stuff?
Now, here's the thing. I haven't seen the indictment, and I haven't read up on the tax law that Alan Weisselberg is facing, but I do know that district. The Manhattan District Attorney's Office is no slouch, and Cy Vance and the team that they put together is actually a pretty formidable team. And they've gotten his records, Trump's records, finally, and it's just amazing what's going to happen. Mark my words. They're going to eat around the edges of this. They're going to really try hard to get Weisselberg to flip. However, one could make the statement that these kinds of cases are not based on witnesses. They're based on documents. And they're not sexy cases. They're not sexy cases at all. But they're based on documents. And so if there's false tax filings, false insurance filings, false whatever. So this is just the first nibbling on the edges of the Trump Organization. You're going to see other indictments coming down. I'll bet, and I don't know whether or when Trump gets indicted. No clue. Do I have a dog in that fight? Hell no. I don't really care one way or the other. But we'll see what happens. It's just interesting, criminal theater, and that's what I'm here to comment on. And lastly, we saw last week that Bill Cosby was released. Now, look at Bill Cosby. Bill Cosby had all kinds of detractors, all kinds of people that accused him of this and that. Well, the woman from Temple University that he was accused of drugging and having sex with, she had a civil suit against him many years ago. And it was a different district attorney back then. And Cosby and his crew, well, his lawyers, not his crew, Cosby and his lawyers struck a deal where, look, okay, if I'm going to give this deposition, the deal is you can't use it and you can't prosecute me. I'll agree to do this if basically you give me a pass. So the statute of limitations was just about to run. You got a new county or new district attorney in Philadelphia or somewhere in Pennsylvania, where he was, and it's just about to run, and they charged him anyway. Now the state Supreme Court in Pennsylvania said that it was a violation of due process to prosecute when he was given basically immunity in exchange for his testimony. I happen to agree with the court's ruling. I did listen to one of the prosecutors who said that she didn't think any kind of agreement like that existed. However, when questioned on the stand, the district attorney said, yes, there was an agreement. It wasn't in writing. It was verbal. But, yeah, there was an agreement. So you have to take him at his word. And if there was an agreement, it's an affront to every defendant for a prosecutor to go back on his word. And here's the thing. Just because that prosecutor is no longer the prosecutor in currently, that doesn't mean that agreement doesn't have to be honored, because it's simple contract law. You have a promise, you have an act on that promise, and then that reliance on that promise is what the violation of the due process was. Because Bill Cosby probably wouldn't have given that deposition or that statement had it not been for that promise to not prosecute him. And that survives no matter who the next county attorney is, that district attorney. The district attorney has to honor what the other one said. So, and then the other thing that they commented on in that opinion was the use of priors, basically prior. It's called 404B evidence, prior bad acts. They had a number of accusers who were able to tell their story that didn't really have anything to do with the current case. And 404B evidence is dangerous because what it is it's when you take a prior bad act and you use it to show act in conformity with. In other words, he did it before, he must be doing it now. You can't do that. The rule actually specifically prohibits it. But you can use prior bad acts for other purposes like common scheme, identity, plan, preparation. But there's a danger that too much of it is a good thing. You know, too much of anything is a bad thing. By that I mean there's a danger that it's more prejudicial than probative. You don't want a jury to convict somebody based on something that has nothing to do with the current crime that they're being accused of. And so while identity and motive, plan, opportunity, preparation, those kinds of things are important in a case like this, especially when the scheme is to drug and then have sex with somebody who's helpless, basically. There is a danger, especially when you're dealing with sex cases, that it's so that people are just going to convict because, oh my God, he did that before. Oh, he must have done this again. What a piece of garbage. You know, there's a real danger to that. And the state Supreme Court in Pennsylvania commented on that. And I think they struck a good balance. And I think, people are outraged that he got free. I am not outraged in the least. I think that the district attorney in Pennsylvania should have honored what the prior agreement was, and that is why the state Supreme Court in Pennsylvania found a due process violation with that, and so they can't prosecute him. He's done. He's absolutely done. So these are just a few of the legal headlines that have been in the paper and in the media last week. So we're going to have more of these kind of updates. And we got some other stuff that we're going to be doing soon. So I just want to tell you guys, thank you for blowing our channel up. I'm Bruce Rivers, board-certified criminal defense lawyer. Follow us on Twitter. Follow us on Instagram. And if you're on Patreon, you get a little priority with some suggestions on what we should go. And here's the thing. I want to give you a shout-out to Michael Rivers. He's going to be on Broadcast Wheeler. Watch his interview. Gives you some kind of insight into the creativity that goes on behind the scenes. Couldn't do it without him. He's my boy. So talk to you guys soon. See you next time here on Criminal Lawyer Reacts.